We're on the record in two cases. First case is cause number 318966. Second case is cause number 322442. Both cases are style State of Texas versus Cleveland James Chambers. The first case, Mr. Chambers, is a motion to revoke probation. The second case is an assault family violence. Now, Mr. Chambers, earlier we provided you with a judge's explanation of rights to defendants without an attorney. You recognize this document?
Yes, sir.
And is that your signature on it?
Yes,
And initials on this
Yes,
document?
sir.
Now, prior to signing this document, did you read everything in this document? This document?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay. Now, Mr. Chambers, your second case, as I mentioned, is assault family violence case. The alleged victim name is Quinteria Green. Now, I have some standard bond conditions
Yes, sir.
that the court has to give to you in both your cases. And you should have that before you. Do you have that before you, the bond conditions?
The bond conditions? Yes, sir.
Okay, I'll go over that, which it says, following the arrest and or accusation in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any person, any defendant named herein are ordered subject to the following additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that?
Yes, sir.
Number 2, the defendant shall not, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and a test indicates the presence of drugs or alcohol in the defendant's body, and that's pursuant to Texas Code of Criminal Procedure, Article 17.44A2 and C2.
Yes, sir.
Number 3, the defendant shall not communicate either directly, indirectly with the alleged victim of the pending offense. And we're talking about the assault offense in
Yes,
this
sir.
case. And the defendant shall not go near any residence, school, or other location frequented by the alleged victim, Quintria Green. You understand that?
Yes, sir.
And let's see. Okay, and now the fourth, this doesn't apply because you don't have a DWI offense, but that only applies in DWI's offense. An individual have to put an interlock device on a vehicle that they own or regularly operate.
Yes, sir.
Now, this is effective today, and Mr. Chambers, the court will instruct you to adhere and obey the standard bond conditions. Your failure to obey the bond conditions may result in your bond being revoked
Yes, sir.
and you being put in jail. All right?
Yes, sir.
Just have a stand over there
Yes, sir.
in front of the court coordinator, and your case will be reset.
Yes, sir.
Oh, this here goes. And your attorney is Miss Laurie Perazzo. That's the attorney that you've been appointed, that's been appointed